Hi, Frank Gray from the law firm of Jimeno and Gray. Today we're going to talk about protective orders in Maryland. If you're watching us on YouTube, make sure to like the video if you enjoyed the content. Make sure to subscribe to the channel, hit the notification bell so you know when we're pushing more content out that'll help you navigate the Maryland legal system. All right, protective orders. Protective orders are one of the most common things that the court deals with on a daily basis. Here's how we're going to break down protective orders. We're going to do it in 3 steps. Number 1 is we're going to talk about who can get a protective order. Number 2 is we're going to talk about the process of getting a protective order. And number 3 is we're going to talk about what the protective order can do to help you. All right, number 1, let's talk about who can get a protective order. In order to get a protective order, you have to be what's called a person eligible for relief. You got to remember that protective orders are meant to be a family affair. It's not meant to be an order to keep you away from your neighbor. That's what a peace order is for. A protective order is supposed to be for people who are related. It may be because it's your spouse or former spouse. It could be a brother, a nephew, another family member. It could be someone you have a child with. It could be someone that you're simply related to by blood or marriage. It could also be someone that you've had an intimate relationship with or lived in within a certain amount of time. For the exact definition to see if you qualify, click on the link down below. Number 2, let's talk about the process. These can happen in either the district court or the circuit court, but how they start is going to depend on where and when you go. Let's start with the district court first. If you go to the district court not during normal business hours, meaning when the court is not normally open, you're going to see a commissioner. A court commissioner is going to give you an interim order that's going to be good for 48 hours after the court reopens. What'll happen is that's a really temporary order. At that time, you'll show up and you'll have to justify in front of a judge that you're eligible for a temporary protective order. So this will put you in the same position as if you had come and sought relief of the district court or even a circuit court when the court is open and you are in front of a judge. To get a temporary protective order, you have to prove that there's a reasonable likelihood that you meet all of the elements, that you're a person eligible for relief, and that there's been a qualifying act of abuse. Now, one thing to keep in mind is if you meet this standard and you're in the district court, but there's a circuit court case involving custody or divorce that's open, the district court can, and a lot of times does, reset them for that final hearing down in the circuit court. If you're successful at the temporary hearing, the court will schedule it for a final hearing. At the final hearing, this is when the other side will definitely be there. Chances are, if it's going to be contested, this will be where it's contested. The petitioner has to go first. They have to prove their case. They have to prove that they're a person eligible for relief, that there's been a qualifying act of abuse, and they have to tell the court what they want to see happen and why. Keep in mind that the standard at the final protective order hearing now is only a preponderance of the evidence. That's more likely than not the 51% standard. So what is a qualifying act? This is something that's really specific, and this is where a lot of cases are won or lost, is whether someone can prove that there was a qualifying act of abuse. So let's go over each one individually. Number 1 is stalking. That's the criminal definition of stalking. That doesn't mean harassment, which means someone is just being annoying. Stalking means that after being told to stop, they're literally following you to different places physically. It's not just emails, it's not just phone calls. That would be harassment. You're not entitled to a protective order based on harassment. This has to be someone literally following you within the criminal definition of stalking. Next is mental injury to a child. This is a really, really tough standard. The only way that this can happen is if the court orders a DSS report. That's the Department of Social Services. And if they say that there's a mental injury, then you have a palatable case. If they don't say there's a mental injury, it's going to be really, really difficult to prove because it's a very specific and very high threshold to prove. Next is false imprisonment. False imprisonment is a common law crime in Maryland. What it literally means is that someone is in a room and you are preventing them from leaving. In other words, you have to be between them and the door. You can think of it kind of like kidnapping, but instead of moving someone from place to place, you're just physically restraining them to keep them from leaving a confined place. One of the most common things we hear is that someone is in a room. So the question is, was there another door? If there was a back door to get out, by definition, it's not false imprisonment because they could just walk out the back door. False imprisonment literally means that someone doesn't have the ability to leave the room. Next is an attempted rape or an attempted sexual offense. Next would be an assault, and this means common law assault, which really means common law assault and battery, which means basically you either do something to scare someone, you're attempting to physically touch them without their consent, or you do actually touch them without their consent. That's the old common law form of battery, touching someone without their consent. Next is an act that actually causes serious bodily harm. That could be kicking, punching, slapping, throwing someone down the stairs, hitting them with an object. Something that actually causes a physical injury. Next is an act that actually places someone in fear of imminent bodily harm. That's one I'm going to have to explain to you. If I call you on the phone and I say that I'm going to come over and chop your head off with an axe, it might make you fearful, but it's not going to meet this definition. If I'm standing in front of your house holding an axe and I wait for you until you come outside and I say the same thing when I'm holding the axe and I walk towards you and raise the axe, meaning I have the literal physical ability to do it at the moment, that meets the definition where you could fear an imminent threat of serious bodily harm. All right, so now we've talked about who the qualifying people are. We've talked about the qualifying acts of abuse. We've talked about the process to get a protective order. Finally, let's talk about what the court can do. So the court can do a lot of different things. At its essence, what the court is supposed to do is the court is supposed to separate people. It's supposed to be an order to keep the respondent, that's the other word for defendant that we use in this context, away from the petitioner. That's the word we use for the plaintiff. So in other words, we want to keep the person committing the abuse away from the person who is being abused. At its essence, that's what a protective order is. Now, in order to do that, in order to put a Band-Aid on things, the court has discretion to do or not do certain things. And in my experience, it really depends on the judge, because judges can vary even within the same county about what they feel comfortable doing under the same fact pattern. One of the things they could order is that there be no contact at all. Or if there are children, they could order that there only be contact about the children and only via text message. A protective order can last for up to 1 year in its initial stage, but a lot of judges don't feel comfortable doing that because they want families to get down to the circuit court in order to get their divorce going. And they feel like if they put something in place, it's going to affect the divorce. So they'll actually make an order shorter than a year in order to encourage everyone to run down to the circuit court and get started with that divorce case. The court can award custody and visitation of children. The court can award use and possession of a home or an apartment that is leased or owned by either of the parties. The court could order the respondent to stay away from the petitioner's place of work or wherever they're going to live. And one of the last things that people ask for a lot of times is emergency family maintenance. It's not specifically defined. In my experience, it's kind of a combination of child support and alimony. It's meant to be a Band-Aid to try and help a family if you have a financially dependent petitioner, meaning the abused, who needs financial help from the respondent who abused them. The court can order this emergency family maintenance. If you or your family is going through a difficult time and you're looking for information about a protective order, feel free to click on the link down below for our free family law guide that'll give you more information about this and other family law topics.